The views and opinions expressed on the Healthcare Advocate Show do not necessarily represent the views and opinions of Connoisseur Media or its advertisers. It's Revolution Healthcare, the show that keeps you in the know about the ever-changing healthcare system. We all need answers to our many questions about health and the revolution in healthcare, presented by Patient Advocate for You, making sure that your healthcare is coordinated properly. And now, here is Sharon Gauthier, taking your calls and sharing information. 1-888-574-2723. 1-888-574-2723.
Good morning, everybody. I'm very happy to be here today, and I was thinking to myself how I was so fortunate that I did not pick the time of 7 a.m. in the morning to do this radio show, which was the original time. We have a wonderful guest today, but I first wanted just a quick word about our sponsors, Home Helpers Home Care. When it comes time to go outside the family for help with a loved one, you want to go to the best. You need home helpers in home senior care. With Home Helpers, your loved ones can continue to enjoy the comforts of their home as they age. You can call 860-698-2244 for a free in-home consultation or visit their website, homehelpershomecare.com. Also, we would also like to thank our other sponsor, which is Protein Sciences. We had Dr. Minot Cox on last week talking about vaccines. Flu season is coming, guys, and you need to protect yourself and your family. Flu block is a better and safer, more effective option. If you think because you're young or healthy you don't have to worry about the flu, think again. Every year, thousands of young, healthy people end up in the hospital because of the flu. Don't be one of them. So ask your doctor or find a clinic this year and get your flu block shot. So this morning, I'd like to give you our phone number. That's the correct one. Apparently last week, we neglected to give you the correct number. So it is 888-574-2723. Our guest today is Marialta Sparagna. She is an attorney out of Simsbury. She's the owner of Melanson Sparagna, an attorney firm that we work with. I've had the pleasure of working with Marialta. She graduated from the University of Connecticut of Business with a master's degree in administration and MBA. She went to Wesleyan University with a BA in economics and graduated from Western New England University with her Juris Doctor, which makes her an attorney. Right, Marialta?
Yes, thank you for having me, Sharon.
You're welcome. So Marialta and I work a lot together, and I thought that she would be a wonderful guest to discuss some of the issues that most people don't think about until there's a crisis. We both feel very strongly that everyone needs to think about power of attorney, conservatorship, living wills, advance directive, healthcare agents, all the things that crises will ask you about that you're kind of put in a corner to make a decision about that should have been discussed long before the crisis. So the first thing we're going to talk about today are living wills, advance directives, and healthcare agent. And whatever order you'd like to put that in, Marialta, that would be great.
Well, let's talk about a living will, because a living will is something that you can decide about and you put in writing in advance of anything that might occur. And it's actually just used in a kind of a really narrow circumstance. It's a document that states your wishes regarding any kind of health care that you may receive. If you're in a terminal condition or permanently unconscious, then the living will tells your physician what you want in terms of life support systems, whether you want to be kept alive, whether you wish to receive treatment, even if the result is your death. Now, it doesn't mean that you won't get pain medication. I mean, they will keep you comfortable.
Correct.
But what you want to make in advance is, well, what happens if you're in a terminal condition? For example, I don't know if anyone remembers a Karen Ann Quinlan case. I'm probably dating myself.
From Florida, with the feeding tube, yeah.
Or Terry Ann Schiavo. If you were in such a state, would you want CPR? Do you want a feeding tube? Do you want to get, do you want IVs that give you fluids? I mean, that's the kind of thing that you can decide in advance. And they don't really institute this unless basically they think there's no meaningful hope of recovery. I really want to emphasize that.
And living means that while you are alive and well is when you make those decisions.
Correct. In advance.
Right.
Yeah.
And families, I often say to them, you need to have those discussions. Even amongst yourself, it doesn't necessarily mean you have to wait till you're 60 to do it, because having come from a trauma background myself, there have been instances where there have been 20-year-olds and 30-year-olds that parents are involved with these discussions, and they never talk to their kids about what they really wanted. So it really is an all-around discussion to talk about what you want, while you're awake and alert and oriented, and it can be very specific, correct?
Correct. The other thing is, if you have an advance directive, what you're doing, and that's a different type of document, but you're appointing someone to be your health care agent. And so what you're saying is, if I can't speak for myself, if the doctor can't talk to me and I can't give informed consent, which means that the doctor doesn't think that you're understanding the type of treatment he would like to give you, whether it's surgery or any other type of intervention, he would like to look to the person that you've appointed. And that's when a healthcare agent comes into the picture. They're your voice. They speak for you. So what I encourage my clients to do is I say, look, whoever you're considering to have, to be your healthcare agent, you need to have a talk. You really need to be frank about the kind of treatments that you would want or wouldn't want. At what point would you like to cut off treatment? Because it's about you. And you have to pick someone who is going to make that decision with you in mind. It has to be a person that can't really let their emotions interfere, because they have to be able to step back and say, okay, I'm making this decision for this person. I may love this person, but I'm doing what they would want me to do. Not about what I want, not about whether I want to keep them alive, but it's about what they would want under the circumstances.
Right, and how they would want to be alive.
Absolutely.
So I actually had a case last year that came to me that had a living will in place. It was a woman who was a very active woman in her 70s at yoga. Okay, so she's very active at yoga. She had a massive stroke. She ended up in the hospital on a ventilator, and they usually within 10 days there'll be a discussion with the families, and I find that neurologists are very honest with families about outcomes. They had a discussion with the family about what they wanted to do. She was very clear in her living will that if she was in a vegetative state, if her condition after an event did not return back to a quality of life that she had prior to it happening, that she wanted nothing else done. The problem with that is that there were 3 people who were her healthcare agent assigned to make those decisions for her. Even though the living will was very clear, the hospital staff went back to the family and said to them, there were 3 girls and a son. We need you to tell us what you want us to do. So when they explained, and when I looked at the records, they were very clear that she was not going to come back from this stroke. She was not going to walk again. She would need a feeding tube, that her life would be spent in a convalescent home. Even with that, one of the people, who was the first person and the youngest in the family, did not want to follow the living will. So this daughter said, I want everything done, against the wishes of the living will and the rest of the family. The hospital followed that because they're always worried about litigation. They followed that. They took her off the ventilator. They put in a tracheostomy. They put in a feeding tube. She went to a convalescent home, and she's spending the rest of her life there, and she will never walk, never talk, not be able to eat, and it was extremely painful for the family. So at that time, they had a family attorney, and I had said to them, you really need to go back to find out what you can do about that. Their only option was to be able to go back to court and maybe remove the daughter who was making those decisions as the healthcare agent. But the more difficult piece of that, which you and I, always face, is even doing that, it's already been done. So now what the family is faced is that they take their mother off the feeding tube, which nobody ever wants to do. That they basically starve her to let her die so that she doesn't have to live in this condition. So no one's going to do that. So what we're talking about is having those decisions made ahead of time, but what really frightens me is that even when that's done, you have a system who didn't honor that. What I had said to them was, if I had been involved prior to this, like when she was hospitalized before all this happened, what I would have requested is that it went to the ethics committee, which every hospital has, for them to make a decision about it and really stand by what was very clear on the living will. So that's just a little bit of a caveat of a living will can be put in place, but then I think there has to be a family discussion once that's done, that all the kids understand, look, this is what I want. I don't really care what you want. At the end of the day, this is what I want. Exactly. And that's why you need to pick someone who's the agent who you think has the courage to make the decision. And pick one agent. And if that agent can't serve, then you have a successor. I know there are a lot of parents who have two children who'd like to say, oh, I want both my children to make the decision. And in that case, you may as well have no one. Because if there's a dispute, then either you go to court or you end up with nobody making the decision and the person not getting what they want. And the system will always err on the side of not wanting to be sued. Right. And I'm sure that that's what they were looking at, is like, oh my gosh, we have this one daughter who wants to have everything done. So it's just really very sad. So a living will and advance directive, is that the same document or can it be the same document? It's often, I say the words are often used interchangeably, because they both are something that you do while you're competent, that give the physician basically orders in advance. Let them know it's okay if you're in that persistent vegetative state and there's no meaningful hope of recovery and there's no quality of life. Under those conditions, that's saying in advance, okay, here's my wish. The physician can act on that. But the thing is, the problem with that is it's a very narrow set of circumstances where that comes into effect. It's actually a healthcare agent. Odds are that's the person who's going to be making the decisions for you if you cannot make them for yourself. So okay. Another case that I had, which kind of reflects also an understanding of what living will, and everyone out in the community, I think, understands that do not resuscitate, do not intubate. That's usually part of the living will piece of it. And most entities that you go into, like a hospital or convalescent home, will ask you right away, what is your status, your code status? Is it a full code, meaning that if your heart stops, we're going to do everything? Or is it a do not resuscitate and do not intubate? The problem with that is that I think there's sometimes a misunderstanding with the family. I had a call from a daughter who was irate because her 85-year-old father went to the hospital with a heart attack. They treated the heart attack. They did not resuscitate him. In her mind, they did not follow the do not intubate and do not resuscitate. And I said to her, well, did they put him on a ventilator? She said no. Did his heart stop? She said no. I said, then what you're talking about is treatment. So they treated his heart attack, which nowhere did it say, if I have a heart attack, do not treat. Now, certainly, if that's what your dad wanted, he can put that in his living will. If I have a heart attack, I do not want you treating me. I just want to pass. But that's not the way it was. So, again, I think a discussion with your attorneys and a discussion with your physician. What we're talking about needs to also go to the physicians, right? Yes. So your physician, who should know you, really needs to know what your wishes are, because even though you go into the hospital and their hospitalists managing you, they will fall back on your primary physician to ask for decisions and help, especially when it's end-of-life issues. And when you get these documents together, it's important to include your physician. We're talking to Marialta Sparagna, who is an attorney and is an expert on elder law. Our phone number here is 888-574-2723. Please call with your questions. She's here to answer them for you. And we are discussing living wills, advanced directives, healthcare agents, and what that actually means. And just begging people really to please be proactive, because Marialta and I have been involved in many cases where that proactivity has not been in place. So a crisis happens, and then she or I will get a call saying, I want to be power of attorney of my family member, and now they're in the ICU on a ventilator. So let's talk a little bit about, and hopefully we'll get some questions about advanced directives and healthcare agent. Let's talk a little bit about power of attorney versus conservatorships, what those two titles mean.
Well, specifically, a power of attorney is if it's and we're referring to someone who can take care of your finances. There's several types of powers of attorney. When you say you have a power of attorney for someone, what you're basically saying is, I'm appointing an agent, okay, someone who can act for me. They're standing in your shoes legally. There are durable powers of attorney, and a durable power of attorney is effective when you sign the document. The nice thing about a durable power of attorney is if you become incompetent, that person that you have chosen can still act for you. There are limited powers of attorney. In other words, if you go to an attorney and, for example, you couldn't go to a real estate closing and you wanted someone to act for you and say, gee, someone might have to go and sign documents for me, you could give them a very limited power. And that would be, okay, you might be able to sign the deed, you can sign a settlement statement, for example. Or if someone came in to see me, depending on what their needs were and what other documents we were drafting, it can be a very broad power of attorney. And some of the questions that you deal with, well, if you're giving someone a power of attorney, do they have power to gift? Do they have the power to apply for entitlement benefits for you? Do they have the power to maybe fund special kinds of trusts which might allow you to get public benefits and still get health care at home? And there are very, deal with taxes, deal with the IRS, deal with your retirement plans. I mean, it's not a one-size-fits-all kind of determination. It's up to the client what they think they might need. Powers of attorney can be changed and done depending on where you are in your life. But it's a good idea to have one, because if you don't have one and you can't act for yourself and you are incompetent, who can sign your checks? Who can pay your bills? And oftentimes, if you end up in a hospital and then you have to go to a nursing home, etc., the hospital or the nursing home may petition for a conservator, which means going to probate court and having a judge appoint someone to take care of your financial situation. By the same token, if it's your health care decisions that you can't make, there's something called the conservator of the person, and that's a person who would decide, what kind of medical treatment you get, where you live, where your rehab is done, whether you get discharged, what kind of place you get to go to when you're discharged, whether it's back home, whether it's to maybe assisted living.
In conservatorship, there's two kinds of conservatorship, correct? Correct.
There's a conservator of person. So if you want to think of it separately, it's like that's the person who worries about your body, your medical care, where you live, your clothing, your shelter, groceries or Meals on Wheels.
But also includes your health care decisions.
Your health care decisions as well, which means what kind of treatment do you get?
And you can do conservatorship of somebody who agrees to it or doesn't agree to it.
That's correct. There's something called a voluntary conservatorship. And under those circumstances, the judge does not make a finding that you are incompetent. There's also an involuntary conservatorship where there is a court hearing and you're represented by counsel, and there's an evidentiary hearing about whether or not you are incompetent. In Connecticut, only a judge can decide whether or not you're incompetent as a matter of law. He hears evidence from maybe psychiatrists and doctors and people who might know you and who have dealt with you. But it's up to the judge to decide. And then once he's decided, he will issue an order. Now, in our state, we try to give the conserved person as much independence and control over their life as possible. So the judge will craft an order which indicates what power the conservator has. So again, it's not one size fits all. It's depending on what that specific person needs.
So I have a gentleman that I'm actually conservator person of. That's part of what, we do. And it's voluntary. And the reason for that is he's blind. So he's blind. He doesn't have the ability to really make his decisions on his own. He needed someone to coordinate aids for him because he needs care 24 hours a day. And so I organize all that for him. But it's a partnership with him and not really the ability to tell him what to do as long as he's able to discuss with me what he wants. If, in fact, he is not, he's unconscious, it then gives me the power to say, I know what he wants and make the decisions for him. If it was involuntary, which I have a few of those, they usually have dementia. There's a physician's document that needs to be filled. So a family member can't just go to court and say, okay, my mom's got $3 million. I want to take care of all of her money. I think she has dementia. Go to court and get conservatorship. So the protection of that is that when you petition the court then assigns that person an attorney, correct, when it's involuntary.
They will assign in order to represent you. In other words, the attorney is not the conservator. The attorney will, if you agree and you say you would like a conservator, they will advocate for your wish. If you don't, they will basically fight the application. So, they're your hired gun in that circumstance.
So it's a protection for them.
Absolutely.
Yeah.
And the court also is protecting that individual because the conservator, whether they're voluntary or involuntary, has to report to the court.
Correct.
So if it's with respect to finances, they need to file an inventory of all your assets. They need to report on a yearly basis about what they've done with your assets, which means they file an accounting.
It's a little more complicated, I think, for the expense piece of it. We're just going to take a break right now. I am talking to Marialta Sparagna, who is with Melanson Sparagna in Simsbury, Connecticut. She is an attorney and an expert on elder law. Just a quick word from our sponsors, Home Helpers Home Care. If you need a home health aid for yourself or a family member, Home Helpers is one of the best. I can tell you from experience, it's very important to hire a reputable company like Home Helpers when it comes to home aids. We've worked with them in the past and recommend them to our clients when a full or part-time aid is required. We don't take this lightly. I have seen what can happen when you hire a person or company that is not reputable. Over the years, I've seen patients and families have money stolen, missing pain medication, injuries, and falls because the aid was not being attentive. Lots of things can go wrong, so don't just trust anyone with the safety and well-being of your loved ones. That's why we recommend Home Helpers. You can contact them at 860-698-2244 or contact them on the web at homehelpers.com, and their consultations are free. I actually do have them right now with a client who is just transitioned into hospice, and what the family had hired the aide for, which turned out to be, a great support for them, is that she really took a long time to eat. So a very competent aide came in and has spent at least an hour and a half each meal time making sure that she gets the nutrition that she needs. So again, just be really careful about the companies that you hire out there and who you're getting to provide care for your loved ones. Our other sponsor is Protein Sciences, and we did have Dr. Minot Cox on last week, who's a vaccine expert. Listen, the flu season is around the corner. Some of you agree about taking flu vaccines, some of you don't. The bottom line is, for anyone who's ever had the flu, they understand how awful that can be, whether you're young or old, and it impacts you. If you have exposure to grandchildren, if you're out in the community or volunteering, even though you're well, think about getting your vaccine. You can get flu block, request it from the pharmacy or your physician. The reason why we particularly like that vaccine and have been supporting and sponsoring flu vaccine clinics is that it's the only licensed flu vaccine that does not use eggs, antibiotics, or influenza virus in any part of the manufacturing process. I think that that's a very good part of the flu block, in that when people complain about having a reaction, sometimes the reaction can be what has been involved in manufacturing the flu vaccine itself, using egg proteins and antibiotics. The other is that flu block has a longer longevity, in that last year when we utilized that for our elderly population, which is most of our population, we found that none of those clients needed to have a second vaccination. It's a common myth amongst people who don't get the flu shot that only old people are at risk. They absolutely are at risk. If you're elderly, you have respiratory issues. But really, the young and healthy, there's no reason for you not to get the shot, because you can still be a carrier and not be affected by it, but then you are spreading it around to everyone else, and it's extremely contagious. Every year in the United States, there's 226,000 people that are hospitalized from the flu. Of those, 32,000 are between the ages of 18 and 49. So it's not the elderly people that you're seeing hospitalized by this. So please, everybody, think about getting your flu vaccine to protect yourself and your family, and do ask for flu block. We're talking to Marialta Sparagna. She is from Melanson Sparagna in Simsbury, Connecticut. She is an elder care attorney, and her expertise is regarding This morning we're talking about living wills, advance directives, healthcare agent, POAs, conservatorships, all the things that all of us need to think about and really don't until a crisis arrives. Our phone number here is 888-574-2723. Please give us a call with your questions. Marialta would be more than happy to discuss with you any of the questions that you have. Right now we're talking about power of attorney and conservatorship. So often what I hear from hospitals is that if someone goes in with a power of attorney, they avoid even talking to the patient. They will say to me, this person has a power of attorney, we really need to talk to them. I find myself educating the staff and saying a power of attorney is only there if they can't speak for themselves. So honestly, the questions that you're asking, go in and talk to Mrs. Smith and ask them. They're perfectly capable at this moment to answer what you're talking about. So there's so much education that I find needs to happen in the whole healthcare system that everyone does not understand what it means and what it doesn't mean.
Well, and also depending on what the power of attorney says, it may not deal with healthcare decisions at all. It may strictly be for finances. So, and the thing is, I would hope that they would always speak to you if you're the patient.
Doesn't always happen, unfortunately.
I know. And you're not always able to speak for yourself.
And when you can't, that's the reason why you've implemented a power of attorney. Now, there were some changes in the law, I think, around 2010, where the documents got split. Can you talk a little bit about that? Because I think there was power of attorney that covered health care and real estate and everything in one, and then they split it off so that it was a health care agent or advance directive. So people who have very, very old power of attorneys, like back from like 1999, do they need to look at those documents?
It might be helpful depending, and here's the reason why. Power of attorneys do not go stale. They are good and they're valid. However, some financial institutions don't necessarily recognize one that's very old for their own reasons, which they're not always clear on. But it does help if you have someone new, a newer power of attorney rather than the older one. I think you're referring to some powers of attorney, and this was a statutory power of attorney, where they would say there were health care matters. That was actually, it was in the statute, and there was a statutory form, and it allowed the person who had a power of attorney to make some health care, directions, and then there's a big catch-all, all other decisions.
Right.
That's a very, very big, broad power of attorney. And what does that mean? Well, okay, it depends on how you're using it and what it's for. But yes, most practitioners now do make separate documents. And the other reason is, someone who's good with finances may not be the person you want making medical decisions for you. I mean, they're two very, very different skill sets, right? Someone who can balance a checkbook doesn't necessarily want to or should make medical decisions. I mean, there's a lot of families that have some people with medical backgrounds, and there's some that have people with financial backgrounds, and maybe you'd like one person to handle one part of your decisions in terms of dealing with your doctors, and someone else with your finances.
Right. So I do get questions about that with some of the older ones, and I always try to redirect them to their attorneys. And, people are a little hesitant to go to attorneys because they think they're going to be so expensive. But what I have found with you and with other attorneys that I've dealt with, many people get a lot of their questions answered with a simple phone call. And often that's all they need. If it becomes more complicated than that, then certainly they need to go in and have a discussion. But oftentimes it's just, what do I do? And they can direct them, and then they make the decision about doing that. So I think that you would support someone having an attorney help them with the process versus going online and just getting a living will that's online, because there's a lot of online documents now that you can get. And are those valid? And is it clearly what people want? And is there a danger in doing that?
Well, the answer is it depends. I mean, there are rules about how documents need to be executed, whether they're witnessed or notarized or whether or not, and if they're not done properly, then they may not be valid at all. So that's one danger. The other thing is, attorneys are trained to ask questions. And even with attorneys, I think most attorneys will say, it's not what you know, it's what you don't know that will come and basically cause a problem for you later. So when you go to visit an attorney, they're going to ask you a lot of questions. And you may be thinking, gee, why are they asking me all these questions? But they're for specific reasons. We're trying to figure out not only what you need now, but perhaps what you'll need in the future. And when we draft things like wills and powers of attorney, advance directives, we're looking towards the future for you. For example, if you're older, you may want to have something put in there regarding, well, if I'm getting older, and my children are going to be my power of attorney, if my spouse can't do that for me, do I want my children to be able to make gifts to themselves? Well, maybe not. Depending on your asset level, there may be decisions somewhere down the road that might affect your ability to obtain Medicaid, for example.
Right.
So
Medicaid is a state-funded program that it has very specific guidelines monetarily, and I think preparing for that is good because there's what they call a look back. So if somebody wants to today say, well, I want to be Medicaid tomorrow, so I have to go into a convalescent home, and the charge for that is $400 a day, which would be picked up by Medicaid. They're really not able to do that in a day if they own a house and own a car because it's all based on assets.
Correct. There's a 5-year look back.
Right.
So generally, there's going to be a 5-year examination of every financial transaction that you've done within the past 5 years. And, if you've given away all your assets, you may or may not be able to get what you need when you need it.
So when you talk to your kids, or you talk to your mom and dad, because we're basically talking about people who are getting older, having a home that is in their name is going to inhibit them from getting Medicaid.
No. There are some exemptions from Medicaid. There are things you can spend your money on and things that you cannot spend your money on. For example, a home generally is considering an exempt asset, especially if one spouse has to go into a nursing home and we want to keep one spouse at home. Well, we want that spouse to be able to live and to continue to live. So the house is going to be protected for what we call the community spouse. They're also allowed to keep a certain amount of assets. And the person who is in the institution or maybe a skilled nursing facility, well, there are things that they're allowed to have too. We want you to prepay your funeral. We want you to have a funeral. We want you to have things that will make you comfortable while you're there and staying in the facility. And we want the community spouse to be able to buy groceries. If the roof needs to be fixed, fix the roof, pay the property taxes.
So that would be all considered in the whole Medicaid process? Like what happens to the spouse? And I do understand that they can stay in there until they die, correct? The spouse can stay there until they die, or does it have to be both of them? Like what happens when they pass away?
Well, that depends. It's not one size fits all. It depends on what their financial situation was going in to the situation. It depends on whether or not, someone's on Medicaid. Some people pay out of pocket the entire time their spouse is in an institution. If we've protected the community spouse, generally the deed would be in the community spouse's name. And where they live is basically up to them after some point. I mean, they may not want to be rambling around the house. They may want to move in with a child, or maybe they want to try something else like a communal living environment, assisted living, independent living, etc. It's kind of figuring out what that person needs for themselves. And there are actually couples where both of them are in skilled nursing together.
Right.
Sometimes in the same room, sometimes on different floors. I've seen quite a
combination of things.
I've seen quite a combination of things.
Yeah, it can be very complicated. We're talking to Marialta Sparagna, who's an attorney. She is an expert on elder law. Our number is 888-574-2723 if you want to call in with your questions. Now I want to talk to you about some of the nightmares that happen when you don't do this, and you and I both have been involved with that experience, even sometimes with power of attorneys, and a lot of dysfunctional families. When you end up with a crisis that happens, and let's say your spouse is in a car accident. I had a case a few years ago where I got a call from a daughter whose father was in a serious car accident. He was in the ICU. He was on a ventilator. He owned a business. So she called me and said, how do I get power of attorney of my dad? I don't have access to anything. So what exactly do I tell her, Marialta?
she should probably call an attorney. And I say that because you can't just get a power of attorney. I mean, there are levels of competence. And an attorney will go in if they can't speak to the person and they don't think that person is competent. And the legal standard for someone to get a power of attorney is they have to be able to enter into a contract. So the attorney has to have some level of confidence
that the person can talk to them.
They can delegate this authority because that's what they're doing. Now, if you've done this ahead of time and you've had the person and you sat down with them and they said, yeah, you know what, my daughter's capable of running my business, so I'd like to give them that specific power in the power of attorney. I mean, you can also do things differently. Well, that's one thing. If someone's on a ventilator, they can't talk to you and they're not, they can't respond, then really you're going to have to go to probate court, file an application to have that person conserved involuntarily, because part of having a voluntary conservatorship is you have to be able, the judge has to think you're competent enough to realize what rights you're giving away.
Correct.
So unless the judge can have that conversation with you, it's going to be an involuntary conservatorship.
And that's exactly what ended up happening. She was in a panic, and when people hear we have to go to court and it's conservatorship, they think that, oh my goodness, it's just such a huge process. So I helped her with the process, but the cost of that, the time involved, getting records, all of that created a huge angst amongst the family. And the other problem that came up is that this is one daughter out of a family of 4 kids. So now you have the 4 kids fighting about, well, who's really going to be the conservator? So it created a lot of family dynamics that wouldn't need to happen if, in fact, they'd had this discussion prior to something happening with him. And a lot of parents think, if I give someone power of attorney, it means that my power is taken away. And they have to understand is, no, your power is not taken away. It's only there when you can't speak for yourself. So again, I would encourage everyone out there to please have discussions with your families. The healthcare system will always go back to the family, having been an ER nurse for a lot of years and been involved with life and death situations. The physicians will always go back to the family, regardless of the paperwork, and try to come up with a consensus of what the family thinks. If you're lucky and you get a family that all gets along together, you can pretty much come up with an option for their loved one in having a thorough education of what's going on. But most of the time, that's not the case. And when you're in a crisis, is not the time to try and make decisions. It needs to be made ahead of time. The other discussion I wanted to have, which you and I were recently involved in, is that when someone actually does have power of attorney, but then they kind of drop the ball. So I had a 60-year-old woman who had a history of alcohol addiction. She ended up in the hospital for a few weeks, ended up being diagnosed with a form of dementia related to alcohol abuse, ended up in a convalescent home, and after 30 days, she had Medicaid. After 30 days, there had to be a placement for her. She was estranged from her family, so her ex-husband kind of peripherally got involved. Her boys, 3 boys that she has, 2 were assigned as power of attorney, one of them not even knowing that he was assigned power of attorney. So I get a call wanting help with transitioning her. The problem was that we did transition her into an independent setting, feeling that she could have some minimal help, which she did receive with a home health aide that helped her with her daily activities. It was quickly recognized that she did not have the ability to be able to be safe and make her own decisions, and only one of the sons kind of came on board, who was very angry about even having to do it, and it just created a boatload of issues. She ended up going to an assisted living from the independent setting because that was a better environment for her in that she was a flight risk. And then when she moved in there, everyone left. And that's when I brought Marialta into it, in that they paid for her to be there for a month, and then everyone disappeared. The 2 boys that did have conservatorship just were not reachable. Like, nobody was responding to anything. So even when power of attorney's in place, then you're left with my discussing with Marialta, what are our options? Our options were to go to court and get conservatorship. But then the process of that, if you can discuss a little bit what that process would be in us petitioning the court, because anyone can petition the court, correct, for conservatorship if they feel there's an issue.
Well, if you have some kind of relationship and you are an interested party and you see something that really needs to be rectified, if someone has no one or if no one is acting, then, as I think I stated before, many times the institution itself, the social worker on behalf of the institution, well, if they have no one to make a decision, if they don't know how they're going to get paid, they may actually file the application.
And they will become conservator.
No, they won't become conservator. They will basically leave that in the hands of the judge. And in the state of Connecticut, most of the probate courts have a list of people who can serve in various capacities, whether it's an attorney or whether it's someone else. And that's either a conservative person and estate. And again, a judge will appoint a conservative estate if needed, a conservative person if needed. And there are two different functions. So even if it's the same person, they get a decree that says, as conservative estate, you can do X, Y, and Z. As conservative person, you can make these types of decisions, and that's how it's left. So the judge decides. And many times, if there's families, if there's been, for example, 2 children appointed or whatever, and they can't agree, sometimes the only recourse is to go to court and have a judge appoint someone, and that very well may be a third party, a neutral third party. If the family can't seem to function and make decisions for the family member.
And, we see that more often than not, unfortunately, kids that just don't get along. When there's money driving it, and it turns out that this woman had millions of dollars. I don't know how she got Medicaid. My guess is that one of her events that she had in the hospital and discussing with the social worker, the fact that she had no insurance did not divulged the fact that she had assets because she'd never worked in her lifetime. She was a mom, so she had no ability to collect Social Security, so she also couldn't get Medicare, and they applied for Medicaid. So now we have a woman who has a lot of assets that the state is paying for all of her care, and that's also creating another layer of problems. So a lot of dysfunctional, and unfortunately, kind of like when I worked in the ER, I used to think that every person out there was driving with drugs and alcohol on board because that's all we ever saw in the trauma room. But, and this is kind of the same thing in that what we see, unfortunately, is a lot of dysfunction. I am so thrilled when I get a call from a family member, and one of our questions in assessing is, well, if there's 4 of you, do you all get along? And when they say, oh, yeah, we all get along really great, I could just kiss them through the telephone. Because that makes things so much easier when there's a spokesperson that's been assigned. Everyone has divvied up what their responsibilities are. You find out who that point person is. And then you can help them, because your job and my job has nothing to do about really taking control. It has to do with helping people keep control of some sort of their own life. Our phone number here is 888-574-2723 if you want to call in. We'd love to talk to you about living wills, power of attorney, conservatorships, the legal documents you want to put together before you can't do it anymore, so while you're with it. So this should be a family discussion, I think, with Thanksgiving coming up. So, Mom, and it's funny, my husband and I go out to breakfast every week. And a lot of dimension is family. He keeps saying to me, if you tell me one more time that you're worried about me. So we had a discussion one day about, well, what are your limitations? Like, when exactly do you want me to say that you've had enough? Does it matter if you know me? And he said, no, not really. Does it matter that you don't know the kids? Because a lot of dementia, his mother, his aunt, everyone had it. No, that really doesn't matter. I said, so what's your criteria? And he thought a minute and he said, if I can't hold the channel changer and change the television, then you can call it quits. So I kind of laughed, but at the same time, I know what his criteria is. It's like, okay, he may not know me, I'm a stranger, but if I go in and he can hold that darn channel changer and watch television, he's okay with it. So it's funny, but we're at least talking about what the criteria is. You know, how do you want to be buried? Do you want to have a cremation, or do you want a big funeral? There's a document called the 5 Wishes. Do you know about that document?
I have read about it, yes.
The 5 Wishes is a document that people can get online. And the great thing about the 5 Wishes is that it's a packet that families can get. Usually the cost of it is a couple dollars. And the families can actually go through it, and it's questions that you ask your loved ones. So I've utilized that with families who feel that, you know, mom and dad aren't dying. Please don't talk to them about it. And I can tell everyone that if you're dying, you know you're dying, so you're not keeping any big secret from your family. But it really goes into specifics, like how do you want to die? Do you want to be buried? Do you want to be cremated? What do you want at your funeral? Do you want people, you know, blubbering all over your casket and being hysterical? Do you want a big party? What kind of music do you want? It was kind of a fun thing to go through, even though it's kind of not a great discussion to have. But it brought these two daughters, where the mother was the matriarch of the family, to a place that they would have never been able to go to. So at the end of all of it, when the woman died, the daughter very calmly called me and said, you know, hospice is here and my mother has passed, and now we know what she wants. And they were able to move forward. So if you are not interested at this point or ready to have a discussion, I would encourage everyone, go to the 5 Wishes, Google it. You can have a document in front of you that really talks about, in kind of a fun way, and has the right questions for you to ask the family, and bring them up, just one question at a time, which is what I've been doing with my spouse, who's 68 years old. I think he's 68, 69. I don't know. You kind of lose track after a while, about what you want, and talking to my kids about what I want. You know, I've already said to my children, look, I love ice cream. So if I become a diabetic, I said to my daughter, this is what you tell the nurse. My mother wants her ice cream, and just give her more insulin, and so she can have her ice cream. Again, it sounds like a funny thing, but find out what they want. I knew with my mother, she had always said to me that her surroundings meant a lot to her. She always wanted to be around really beautiful surroundings. We made sure that happened. You know, she was very much a lady. She always wore makeup. She always had a beautiful home. When we got her into assisted living, we made sure that her apartment gave her the beautiful surroundings. So it makes you feel better as a family member, I think, that you've honored their wishes. But you need to have the discussions and not impose what your wishes are on them, which often happens at the end of the day. So I'm wondering, Marialta, if you have any story to share with us that has been a problem.
Well, I do want to interject just for 1 minute, and I have to tell you that one of the reasons I do this for a living is when I was 15 years old, my grandfather was diagnosed with cancer. And back then, cancer was whispered.
Oh, yeah.
They didn't really talk. I mean, nobody wanted to talk about it.
Yeah, you're absolutely right.
And my mother made the decision that we weren't going to go and visit him. She didn't want to see him in the state. But what I most remember, and I don't know to this day if she's heard the conversations, but I overheard the conversations that she would have with her brothers and sisters and mom, fighting about whether or not he could have a feeding tube, fighting about whether or not that he could have an IV. So that made an impression at a very young age.
Wow.
And that's...
It's one of the reasons why you're doing it.
It's one of the reasons that I do that. And I know that when my grandmother, who had 6 children, she was still competent, but getting near the end of life, and I went to her and I said, Grandma, who would you want to make the decisions for you? I said, and I was a lawyer at the time, and I could do that for her.
Right.
And she did pick one. Of course, it was hard for her. Like, Graham, with all these kids, you need someone.
Yeah. To be your voice.
To be your voice.
And you want that voice to be the right voice.
And I have several cousins who had early onset dementia, who died quite young. And so, as an elder law attorney, I've lived a lot of this personally, from all angles. So I'm really compassionate about this. And I look at this as a lawyer and go, we have documents. In this society, we allow people to make decisions for themselves in advance or to talk to people. So start the dialogue. Talk about it. Nothing bad is going to happen just because you raise the issue.
Correct. And these documents are going to be asked for. That's the thing. Every time I go into the hospital with one of my clients, they could have been there the week before. They're going to ask me for that document again for the living will. And that's a protection, because in that week's time, that person may have decided to change who the person was or change their living will. As annoying as it is for me to say, oh my gosh, I just gave that to you last week, what's the problem? The system is there to protect you. Sometimes they bring it to the nth degree. That creates a lot of barriers, but they're going to be asking for these documents. And if you look at them and say we don't have them, that's a big problem for them and for you, because now you're going to be faced with having to make these decisions without a lot of education as to how to do it, or even what your loved one wants.
Right. And even if there's a conservator, the conservator is going to have to try and figure out what would you have wanted, because the conservator is going to use substituted judgment, not best interest standards. So they're going to have to ask your relatives if there's someone around, or if you had at some point in your life, done a living will, or if you have some kind of advance directives, if you've written something. I mean, they're obligated to basically kind of research it and look to see what you wanted. But if you don't leave anything for someone to look at that sets down what you want, then
they're going to use their own standard.
Then they have to. Yeah, they're not supposed to. But what else are you left with? It's you're putting someone in a very difficult.
And then in most of those cases, with my experience in ICUs and in the ER, it will usually be they do everything. And doing everything isn't necessarily what that person might want, because it may leave them in a state that is no quality of life. So now you're judging a quality of life for them, so you need to make the decisions ahead of time. I just wanted to mention, before our show ends in about 5 or 6 minutes, that next week on our show we're going to have Nora Duncan, who's the State Director of AARP. Many of you start getting those memberships at the age of 50. I remember thinking when I turned 50, oh my gosh, I'm getting AARP already. They really are huge advocates for the seniors. We can talk to Nora a little bit about what the Connecticut Chapter does. I know a few years ago there was a class action suit that was generated by the AARP regarding admissions and observations, because what was happening is that people were going into the hospital and not getting admitted for days at a time and put on observation, which meant that if that person needed to go to a convalescent home for rehab, the onus of paying for that was on the family. I had a lot of theories, which I can share at another time, as to why they were doing that. But when I'm getting calls from people saying my mom's been on a unit for 5 days and they just told me she's never been admitted. So Medicare had to get involved and make the change in what Medicare ended up doing. And it was really because of part of this class action suit is making a decision of exactly what observation was. So everyone can tune in next week for Nora Duncan. She's the State Director of AARP for Connecticut, so we can find out the benefits of that. So any other thoughts? Can you share with us a short story on, what nightmare you may have had with?
Well, there are several. Inevitably, and I do make house calls, and I will go to a hospital occasionally.
Oh, that's really good to know.
And
unfortunately, we always get dragged into a crisis, which is never a good time for anybody to be involved, which is why we're talking today, to try to avoid that.
I mean, it's very, I will go, and if I can, help someone and make the documents if I feel that there is, that they're competent, that they can, that they can do this, then I will do it. But it is very difficult to have to look at a family and say, you know what, I am sorry. I don't think that I can, in good conscience, and, do a power of attorney or do a healthcare agent for this person, because they're not competent enough, and I don't think they're, they can speak for themselves. They have to be able to communicate themselves as to what they want, and I have to think that they're understanding what they're telling me. So I don't like being put in that position.
And then they're looking at conservatorship. So if you can do it sooner rather than later, if you do it before you need it, that's a good thing. There are a lot of people every year who are maybe 30 or 40 or 50, they're in a car accident, or they walk in and they get diagnosed with stage 4 cancer. I mean, it's kind of better when you're trying to deal with your health care that you already have your house in order, so to speak. And if you're an adult, it's kind of something you should do. You're an adult, be an adult, make your decisions, get it done. It's not as expensive as you would think. There's many attorneys out there who are, sliding scale and not very expensive. I think every attorney out there feels obligated to do some kind of pro bono work, which means they will do it for free. Yeah. And there's actually an association that you belong to. You want to talk a little bit about that?
Well, I'm a member of the National Academy of Elder Law Attorneys. I'm in the Connecticut Chapter. I'm on the board of Plan of Connecticut, Plan Lifetime Assistant Network of Connecticut, and they have special types of trusts which help people stay on their public benefits as well as either get home care, and which the state will assist in paying for that,
right, or
disabled children for families who have children who are disabled and they want to fund a trust so that they can do some things after they're not there to look after them, that there's something left for that person, and that won't basically make them ineligible for their assets, because many of the programs out there are asset tested and income tested. So it's trying to allow disabled people a little more than what Medicaid or the state would pay for.
So I think my advice, and it may also be your advice, is that the attorney that you have that did the closing on your house may not be the attorney that you need to get involved with trusts and wills, that's an expertise in itself. So the choice of the attorney that they have honestly needs to be carefully looked at, and be sure that when you're speaking to the attorney that you have, when they say, yes, I can do this, that they really understand what it is that they're able to do, and are they expert at that. Do you agree that probably is a good assessment of what they should look for in an attorney when they're talking about trusts and wills?
It depends on the attorney. Attorneys, if you're competent to do something, then you're allowed to make the decision, and you can do whatever you want. But you should interview your attorney and make sure that, they're an attorney that's right for you.
It's a good idea. And I would also advise that people do not put their living wills and their wills in a lockbox at the bank, because I've walked into crises many times where I've said to the family who's now flown in from out of state, where is the living will? Oh, well, it's in the lockbox. They have no idea how to access it. So that's kind of an old school way of protecting documents. They need to have the documents with them, and they need to have copies of it. They can have several copies so that all the family members have them also, and it's not in the lockbox at the bank, because now they're looking for the key, and then they need permission to go into the lockbox, and it just creates a huge problem. And that was a problem for this particular woman when it came to her living will, the 60-year-old, because one of the sons says, I think she's got a living will, but it's in the lockbox. So he goes with his power of attorney to the bank, but he doesn't have the key. So I would just like to thank everybody for coming to our show today. We were talking to Marialta Sparagna, who's an attorney regarding elder care. Thank our sponsors, Home Helpers, Home Care, and also talking to our other